go back there a second. Thank you. You can at the very corner.
Yeah. The subcommittee will come to order. After recognizing myself and my good friend, the ranking member of our subcommittee, Ted Deutsch of Florida, for 5 minutes each for our opening statements, we will then recognize any other member seeking recognition for 1 minute. We will then hear from our witness, and without objection, the witness prepared statements will be made a part of the record, and members may have 5 days to insert statements and questions for the record, subject to the length limitation in the rules. And I'd like to say, first of all, I apologize for not having a lot of members here. There's a lot of activity going on right now, and our GOP caucus is having a big briefing on the pending Supreme Court decision on the subsidies for Obamacare, so I apologize. But you have the best right here. The chair now recognizes herself for 5 minutes. As part of this subcommittee's continued efforts to perform our oversight functions of the State Department and of the Iranian nuclear negotiations, we're convening this hearing to take a look at the state's compliance with the Iran, North Korea, and Syria Nonproliferation Act, known by its acronym, INCSNA. INCSNA, by state's own admission, is an extremely important and effective tool to address the threat of the proliferation of weapons of mass destruction, WMD, and ballistic missiles. It could be even more effective if we pass an updated version like the INCSNA Modernization Act that I authored in 2011, which passed the House overwhelmingly with a vote of 418 to 2. This law requires that the President, who has delegated the authorities in INCSNA to the State Department, to provide a report to our committee every 6 months, identifying individuals who are believed to have sent or received certain items or technology from Iran, North Korea, or Syria. These individuals would then be subject to specific sanctions as detailed in the law. Well, the GAO office, Government Accountability Office, was asked by Chairman Royce to examine the implementation of INCSA by the State Department, to review its reporting process and identify the impact of that process on the imposition of sanctions against the Iranian regime. What the GAO found was that the State Department has been extremely delayed in providing the requisite reports to Congress. Of the 18 legislatively mandated reports that the department was to issue to date, it has only issued 6 of these reports. The latest report we received was not only late, it took state almost 3 years to prepare the 2011 report that we received in December 2014, but this report sat awaiting approval on the Deputy Secretary of State's desk for over a year. Can you follow that? So it took state almost 3 years to prepare the 2011 report. We received it in December 2014, but the report sat awaiting approval for over a year. So state reportedly told GAO that one of the major causes for delay is the vetting process of the individual cases. Each cycle, state has unilaterally made the decision to package cases together. That's the problem, and move them through the process at the same time. So what ends up happening is if we have one problematic case, well, that case can hold up the process for all of the other cases. Instead of pulling that case aside for processing in the next cycle, state holds up the entire package until all cases have been cleared, thus holding up indefinitely the sanctions on all of these individuals. Because remember, it's not just a report. We want to know who is being sanctioned. So while we're waiting and waiting and waiting, no one is getting sanctioned. While we're waiting for an entire group to be processed because of one problematic case, we're allowing these other individuals to continue to help Iran, to continue to help North Korea, to continue to help Syria, and they'll skirt sanctions and proliferate weapons of mass destruction. This is a huge blow to the intent of the sanctions and their effectiveness, as well as a huge blow to our national security. But let's look at the timeline of the last report for a moment. We received the report, as I said, in December 2014. It sat on the desk for over a year. In November 2013, President Obama announced that the P5+1 had reached an agreement with Iran and we were ready to implement the joint plan of action while they continued to pursue a final agreement. If we connect the dots, the administration had actionable intelligence and a legal obligation, let's not forget that, to sign off on the report and sanction these individuals. But the administration sat on this. They did not file a report, and the administration did not sanction these individuals. This flies in the face of all of the times that the president and the folks that we know have said that the U.S. will continue to fully enforce all of the sanctions on Iran while the negotiations were ongoing. That's what the administration says. What they're doing is quite differently. Each and every one of these times, they knew that this was less than truthful. The reporting requirements of the law is clear. State is required to submit INCSNA reports to Congress every 6 months, yet the State Department took it upon itself to ignore this requirement. The requirement is not a suggestion, it is the law. And as the Iran nuclear negotiations continue, we're also left to wonder what other sanctions is the administration not enforcing that it should or that it must. We already had the recent report from the UN panel of experts that said that the U.S. and other nations were not reporting Iran's sanctions violations to the Sanctions Committee. Ambassador Power was here in this very room yesterday, and I asked her about that, and she too stated the administration has been above water, has been fully enforcing all of the sanctions. But when it comes to the nuclear negotiations and Iran, I'm more inclined to believe that the administration is purposely misleading Congress and is in fact not following the intent and letter of the law. This GAO report should be just the tip of the iceberg, and I commend Director Melito and his team for their hard work in putting together this report. Thank you. And now I yield to to the ranking member of the subcommittee, my good friend, Mr. Deutsch.
Thank you, Madam Chairman, for holding today's hearings. I want to thank the Chairman for her continued legislative efforts to strengthen the Iran-North Korea-Syria Nonproliferation Act. You've been tireless in your efforts to keep focus on the nexus between these three regimes and their quest for weapons of mass destruction. As we heard in our hearing on Iran's ballistic missile capabilities last week, the relationship between Iran and North Korea with respect to illicit procurement is vital to the Iranian regime's efforts to circumvent international sanctions. We know that the Iranian regime has been unabated in its support for Assad over the past 4 years, and the potential transfer of sensitive technologies or weapons to this murderous regime that has shown it's more willing to use and continue to use despite its obligations under the Organization for Prohibition of Chemical Weapons Agreement, chemical weapons that it is willing to use against its own people. INCSNA was enacted and subsequently amended to shut down illicit procurement and transfers. And first, let me say that I appreciate the GAO's work on this report. I appreciate the State Department's willingness to make comments on GAO's findings and accept the GAO recommendation. We know that building and enforcing a sanctions regime is complex, and I commend the work that the state has done to enact punishing sanctions on bad actors over the years. The ongoing nuclear negotiations with Iran was a prime example of the effect sanctions can have, although I'd respectfully note that the purpose of sanctions is to change behavior, not simply to come to a negotiation. However, it's clear from the GAO's investigation that there's been a failure to comply with the particular 6-month reporting requirement in INCSNA. And while I respect and appreciate the time that it takes to adequately verify sensitive intelligence and to work through the interagency process, I'm concerned that the State Department's decision to issue annual reports instead of every 6 months is causing a lag time in the imposition of sanctions. Again, I know that it often takes quite a bit of time to meet the requirements for a sanctions determination, but I agree with the GAO that finding that one outstanding determination should not delay an entire report. Isn't there a process in which state can issue its 6-month reports to Congress while denoting an unfinished investigation? Further, I'd like to understand more as to why GAO found that the longest delay in the issuance of a report seems to be at the Deputy Secretary level. How does this reporting requirement differ from those in other sanctions legislation, and are those requirements being met? Finally, and perhaps most concerning, is that the INCSNA process seems to differ from other sanctions determinations in which sanctions are not levied until a report is issued to Congress. I'd be interested to hear if, in your interviews with the State Department, any discussions took place with respect to potential legislative changes to the underlying law. In cases where sanctions have been imposed, the majority of these sanctioned persons have been located in China, Sudan, Iran, and Syria. Strikingly, 17 of the 82 sanctioned entities have had sanctions imposed on them more than once. So understanding that INCSNA sanctions need to be renewed every 2 years, I'd be interested to hear more from State as to why there are repeat offenders. Is the lag time between the issuance of reports, which then can trigger a sanctions designation, allowing these actors to continue to engage in sanctionable activity? Mr. Melito, I appreciate you being here today to explain GAO's findings, and it's my hope that we can work to implement whatever changes in process are necessary to ensure that we are acting as quickly as possible to impose sanctions on those who aid and abet the world's most dangerous actors. And with that, Madam Chairman, I will yield back the balance of my time.
Thank you very much, Mr. Deutsch, for that excellent statement. Excuse me, Mr. Trott, you're recognized.
Thank you. I want to thank the chairwoman and ranking member for calling this hearing to focus on the administration's failure to comply with the reporting requirements of the Iran, North Korea, and Syria Nonproliferation Act. INCSTA is supposed to provide the United States government with an important and flexible tool to achieve its nonproliferation objectives and a method by which to impose sanctions to accomplish this important goal. Unfortunately, due largely to political concerns with Iran, the administration has failed to comply with INCSTA, which has only heightened concerns in Congress with the ongoing nuclear negotiations. Continued reluctance to enforce these sanctions significantly compromises our credibility and nullifies INCSTA's effectiveness as a tool in helping to curtail the proliferation of weapons of mass destruction. I urge the administration to comply with INCSTA, as failure in this regard will most certainly result in the proliferation of weapons of mass destruction. Not only does noncompliance with this act put the United States at risk, but it also threatens our friend Israel. I look forward to examining the reporting history with respect to INCSTA and trying to better understand why there have been delays in the reporting and what the impact the delays have had on the proliferation of weapons of mass destruction. I yield back.
Thank you very much, sir. Mr. Clausen of Florida is recognized.
Yield back.
Thank you. And now we're pleased to recognize our witness. We're so pleased to welcome Dr. Thomas Melito, Director of the International Affairs and Trade Team at the Government Accountability Office. He is responsible for the GAO's work on international sanctions and nonproliferation and has recently completed a review of the implementation of the U.S. and UN sanctions on North Korea. Thank you, Dr. Melito, for being with us here this afternoon and for the work of all of the folks on your team that helped put this very important document together. And with that, your written statement will be made a part of the record. Please feel free to summarize and present your findings.
Thank you. Madam Chairman, Ranking Member Deutsch, and members of the subcommittee, I am pleased to be here to discuss GAO's work regarding states' implementation of the Iran, North Korea, and Syria Nonproliferation Act of 2006, which is referred to as INCSNA. INCSNA targets the transfer of prohibited items related to weapons of mass destruction. INCSNA requires that state provide Congress with a report every 6 months, and state cannot impose sanctions until it has done so. My testimony is based on a report which is publicly released today. I will focus on 4 topics. First, states' timeliness in providing Congress with INCSNA reports. Second, states' process for preparing these reports. Third, the potential impact of states' reporting timeliness on the imposition of sanctions. And fourth, GAO's recommendation and states' response. Regarding the first topic, state has not provided reports to congressional committees in accordance with INCSNA's 6-month reporting requirements. Since 2006, it has provided only 6 reports covering 2006 through 2011 instead of the 18 reports that INCSNA required. State provided these reports at irregular intervals averaging 16 months. It provided its most recent report in December 2014, 22 months after its prior report. Regarding the second topic, state's process does not allow it to comply with INCSNA's 6-month reporting cycle. The process is complex and lengthy, involving multiple interagency and internal reviews regarding each group of reportable transfers that first came to its attention in a single calendar year. It then determines whether to impose sanctions on foreign persons associated with those transfers. Under this process, State does not provide a report to the committee until it has resolved concerns it may have regarding any of the transfers in a particular annual group. As a result, a single problematic case can delay State's provision of a report, which may include other transfers that State may be otherwise ready to report. Moreover, State's process requires officials to begin preparing a new report every December, regardless of whether they have completed and provided all previous reports. As a result, they must manage the preparation of a backlog of multiple draft reports, each addressing a different year. For example, State data indicate that in the last 6 months of 2014, State officials were simultaneously managing the preparation of 3 draft reports covering calendar years 2011, 2012, and 2013. State's delays in reporting on transfers have also recently increased, growing from 26 months for the 2010 report to 36 months for the 2011 report. Regarding the third topic, State's process limits its ability to minimize the time required to impose INCSNA sanctions. INCSNA requires State to identify foreign persons in a report before it can impose sanctions on them. Under INCSNA, State is expected to decide on sanctions between 6 and 12 months after it first obtained credible information of your foreign person's involvement in a reportable transfer. However, under State's process, the actual interval between a transfer and the opportunity to impose a sanction has been considerably longer. For example, State did not impose sanctions on 23 foreign persons for transfers it first learned of in calendar year 2011 until December 2014, between 36 and 48 months after the fact. Regarding our fourth topic, GEO recommended that State should reconsider INCSNA's reporting process to ensure that it, 1, complies with INCSNA's 6-month reporting cycle, and 2, minimizes delays in its ability to impose sanctions. State officials concurred with our recommendation. However, in commenting on our findings, they raised some concerns. State officials commented that our report does not take into account the inherent difficulties of meeting what they characterize as the law's tight deadlines and a substantial increase in scope of reportable activity. In response, we note that INCSNA's scope has not changed in 2006, and that the time required by State to provide the reports to the committee has increased since 2006. State officials also commented that our report does not place sufficient priority on the need for careful preparation and thorough vetting. We recognize that State must thoroughly vet each INCSNA transfer and that some transfers may require several years to investigate. However, our report demonstrates that State should consider a more efficient process for meeting INCSNA's deadlines. Under its current process, State's practice of reporting transfers in annual groups could allow a single, problematic transfer to delay the reporting of other transfers that State may have already investigated. Madam Chairman, Ranking Member Deutsch, and members of the subcommittee, this completes my prepared statement. I would be pleased to answer any questions you may have.
Thank you very much. And thank you again to your whole team for the great and difficult work that you do all the time. The findings in this report are very troubling, and not only from an oversight perspective for us as members of Congress, but for anyone who believes that the laws of the land are indeed meant to be followed and that no one is above these laws. And they're also disturbing because of what they tell us about the lengths that the administration will go to appease the Iranian regime in its misguided and dangerous quest to reach a nuclear deal with Iran and forge some sort of legacy for President Obama. Those are my words, not yours. I realize that. But in your report, you mentioned that State officials said political concerns, including international negotiations and foreign relations, can delay the reporting process. Did the negotiations between Iran and the P5+1 factor in the decision to delay the latest report? What were you told?
We can't actually comment on a public setting on that. We are able to talk about the process in a public setting, but when you get into discussions of countries and individual cases, it actually goes to a very high level of classification very quickly.
Thank you. No worries. GAO found that state actually ignores the 6-month requirement and focuses on yearly reports, as I said and you verified. The state decide on its own to submit yearly sanctions reports rather than adhering to the legally required 6-month schedule. Do they do that on their own?
State has created a process that envisions annual reports. And when we asked them why, they thought that was the most efficient way to do it. So it does not envision 2 reports a year, it only envisions 1 report a year.
Did anyone at state acknowledge that they are violating the law with this practice, that until it's changed, that is the requirement?
We asked that question several times, and I don't think we ever got a clearly definitive answer on that.
In response to your report, state assumed that the committees were okay with the reporting process. And however, it's extremely odd since the year 2011, I authored and the House passed the INCSNA Reform and Modernization Act, and states' failure to meet the requirements of this law, particularly with respect to the reporting cycle, was a part of that effort and has been raised with the department in multiple instances. Which specific offices within the State Department did you have access to? Did you ever engage or have sufficient access to the Deputy Secretary's office or those in the State Department who dealt with Iran sanctions generally, such as the Deputy Coordinator for Sanctions? And related to that, which offices did you request meetings with, and which offices failed to either get back to you or turn down your request for meetings?
So we had, I would characterize as highly functional access to the working level, which was the ISN, the International Security and Nonproliferation Bureau, which is the bureau responsible for preparing the annual reports. We did realize, given the nature of what we were finding, that there was a need to engage higher level officials, and we did request a meeting with the deputy's office as well as the coordinator's office, and we were not granted that meeting.
And finally, GAO provided state with the opportunity to comment to the report and submit those for the record. Department officials, according to your report and the comments, repeatedly cite the difficulties of meeting the tight deadline, and even went through the trouble of bold-facing and underlining the fact that they need time to identify every foreign person in each group. GAO also noted that this practice of reporting individuals in entire groups could allow a single problematic case, as we talked about, to delay the reporting of an entire group. Why wouldn't states simply remove the problematic cases, allow the other ones to be processed through? And did you suggest this as a workaround for the state and State Department? And if so, what was their response?
We went through our understanding of how it was working with them on multiple occasions. And at what's called the exit conference, where we go through our findings, we went through exactly that scenario where we were seeing single cases holding up the process. And we explored with them their opportunity to maybe revisit the process and change it. And they were quite resistant. They've had this process for probably 10 years, and they seem to think it works and it's very efficient. But I think the why is probably better asked of State Department.
Thank you very much, Director Melito. And now I recognize Mr. Deutsch, the ranking member.
Thank you, Madam Chairman. And Madam Chairman, I apologize, but after my line of questioning, I have another committee meeting that I have to run off to. Mr. Melito, in the course of your discussions with State Department, did they indicate that meeting the 6-month reporting requirement is too difficult and that they needed changes made to the law?
They recognize they have a backlog. They recognize they need to clear that backlog. They also say that once they clear the backlog, they're going to go back to a 6-month reporting cycle. I don't know exactly what changes they have in mind. So we did ask them whether they thought 6 months was not reasonable. Would you want to explore changing the law? And they said actually they wanted to leave the law as it was because they thought it was working as intended.
Well, what did they think the impact on the law was of the 36 to 48 month delay that you referenced?
Well, we brought up that the threat of a sanction may lose some credibility when there's such a long time between the actual observation of a problematic transfer and the actual sanction decision. They disagreed. And they thought that what is going on during this period of time, there's a lot of behind-the-scenes discussions with other governments and trying to forestall other transfers, and I'm confident that that is actually happening. But the actual ultimate result, if you can't succeed, is a sanction.
Right.
And the credibility of the sanction does require some timeliness.
And did state give your team any justification as to why they choose to look at potential violations only on an annual basis?
So one tangible thing they have is they have to look at lists of technologies that are possibly are controlled. They have international lists and they have their own internal list. If they decide in 2010 to add a new item, it can't be retroactive to 2010. It can move forward. So they're saying that by keeping cohorts together, they won't create any confusion on that. But that does seem like something that could be managed.
Because you suggested in your testimony that there's a more efficient way to do it.
More efficient way is to release the cases as they're finished. We agree that some cases are very difficult and should take as long as they're taking, but they acknowledge that when the report comes out, some cases have been finished for a long time.
Wait, so what's the response as to why they shouldn't be reported as they're finished?
I think I gave you the answer they gave us. If it's not satisfying, it's because it wasn't satisfying.
Okay. Did the state indicate that the process that it uses to investigate and make determinations for these sanctions differs in any way from the process they use for other sanctions regimes?
So the biggest difference is the way that the requirement to sanction has to first follow a report to Congress. We've looked at quite a number of Iran and North Korea and other sanction regimes, and there's a very similar deliberative process both within state and across multiple agencies. Some of the same working groups are involved in other sanction regimes. All those, though, culminate with an internal decision by either state or treasury to sanction. Inkster seems unique, from my perspective, in that it first requires a report to Congress.
So in all, just to refer back to my friend's comment earlier, in all of the other Iranian sanctions programs, they reach a determination, saying they make a designation, sanctions are applied. It doesn't appear that the goal then is to appease the Iranian regime.
I really couldn't comment on that one.
Okay. Did the department acknowledge that it could issue reports that acknowledge in some way that at least that there were investigations that were still pending?
We know that there currently, at the end of 2014, were simultaneously preparing reports of 2012, 2013, and I'm sure they're beginning to think about a 2014 report. So there are, we know they're doing what they need to do. They are monitoring activity, and they are preparing case files, and they are discussing this internally in the State Department and across. It's reaching the final decision that seems to be what's taking so long.
And just getting back to the first question I asked, so they believe that once the backlog is cleared up, the law doesn't need to change because once the backlog is cleared up, then they can get back to the requirements, meeting the requirements that are set forth. Do they tell you when they anticipate that happening?
They did not.
Okay. Thanks, Madam Chairman.
Thank you. Excellent questions. Thank you, Mr. Deutsch. Mr. Trott is recognized.
Thank you, Madam Chairwoman. You said a minute ago, sir, that reaching a final decision seems to be the problem. Can you explain why reaching a final decision is so difficult?
I can only tell you in a general sense and what's publicly available. They have to, first, the intelligence community has to determine whether it's publicly possible to report the information, the names of individuals, and they also want to go through the deliberative process of working with other governments and making sure that they've got a sufficient case file. So when you're dealing with other overseas entities and trying to make sure you have the right person and you have enough evidence, this can take some time.
So is there any evidence or do you have any sense that the administration's general indifference and insouciance towards taking action on the world stage is a contributing factor?
I cannot comment on that.
Okay. Is there anything in INCSTA that requires that the State Department review and vet individuals as a group? Could they do it individually?
The law does not say how this should be done. It just says it has to be done every 6 months.
Has anyone suggested maybe that since they're so backlogged that they develop a different process, or are weapons of mass destruction not a big deal?
I think if they were to implement GEO's recommendation, they would create a new process.
Okay. So the State Department officials told you that they believe that the threat of imposing sanctions can be as effective as the imposition of sanctions in achieving the behavioral changes that sanctions are intended to motivate. Did they provide any information or analysis to support the idea that the threat of sanctions against these three countries could be as effective as actual sanctions?
To get into specifics on that assertion on their part would actually not be possible at a public hearing.
I apologize. Not be possible because of...
In a public hearing.
I see. Okay. So basically, they're treating these three countries like we'd treat England, France, and Australia. Would that be a fair summary? Okay, I apologize. I'll move on. Actually, that's the extent of my questions. I yield back. Thank you, Madam Chairwoman.
Thank you very much. Mr. Higgins of New York is recognized.
Yeah, thank you, Madam Chair. I just wanted to focus on the North Korean agreement that was signed back in 1994. And, you know, it seems as though that agreement was fundamentally flawed in the first instance because of its brevity, because of the lack of inspections, and just the lack of detail in terms of both infrastructure and nuclear material. What was the stated objective in 2004 in signing that agreement with North Korea?
That is outside the scope of what GAO did. I can talk to you a little bit about how state is implementing sanctions on North Korea, but actually what the State Department was thinking when it signed an agreement, I can't really speculate on.
Well, was it to keep North Korea from obtaining nuclear weapons?
I'm sure that seems like a reasonable expectation.
And how many nuclear weapons does North Korea have today?
I know they have more than one.
And they have a pretty considerable atomic program? What inspections are in place relative to the North Korean nuclear program?
We reported last month that the U.S. government's imposition of sanctions on North Korea had been hampered by the need to identify specifically North Korean individuals, and given they're a closed regime and we don't have good access. Following the Sony hack late in 2014, the president signed a new executive order which changed the way sanctions against North Korea are implemented.
Right.
Now, if we are confident that an individual is either a member of the Workers' Party or a member of the government of North Korea, we can sanction. They don't necessarily want to do that just because of those things, but it allows them to have a lower level of evidence before they can actually implement the sanction. So they think that's going to actually help in the months ahead.
And how's that going?
Well, it just got implemented.
I see. Well, you know, it seems like, I mean, there are some fundamental differences here between North Korea and Iran. I mean, you know, the domestic policies of Iran, or politics of Iran, are that a vast majority of that population is very young and wants to normalize relations with the rest of the world. And that is, you know, fundamental, I think, to America's leverage in negotiating a deal with Iran. Where North Korea, it's almost, they kind of pride themselves on being isolated from everybody. And it just seems to me that you know, there's a pride in North Korea boasting that its atomic arsenal is enshrined in its constitution. And so it just seems like, you know, this is a weak agreement to begin with and more cosmetic than it is substantial, which I suppose the good thing is maybe it has influenced or informed the negotiations with Iran, that this has to be a lot more serious than one with North Korea, because it's almost like we don't have an agreement with North Korea.
There's nothing equivalent to the JPOA with North Korea. That's correct.
Yeah, okay. All right, I'll yield back.
Thank you so much, Mr. Higgins. Mr. Ice of California.
Thank you, Madam Chair. Mr. Melito, I'm trying to go back to some basics and understand this a little. President Clinton signed a law requiring this report. President Bush twice signed laws requiring this report. Before we get to President Obama, either one of those presidents make progress on delivering reports in a timely fashion from your looking at history?
We identified some delays in the past, but we we focus on INCSNA, so we really focus heavily from 2006 forward.
Okay,
we
so
really-
the previous presidents were not perfect. We're not going to give either one a pass. But since 2009, when President Obama came in, you've seen this problem of essentially almost non-compliance, going through the motions, but 3 years seems like not even close to a semi-annual report. Is that right?
That's correct.
And their statement to you is, we're going to do better. That's kind of like the guy that owes you money saying he'll pay you when his brother straightens out, but then you find out his brother's a hunchback. Okay, you know, he will not straighten out. This does, I know that's so insensitive. The fact is, this is a problem that's not going to straighten out in the last 18 months of this administration. Isn't that true?
I think
I know you believe in the redemption of souls, I'm sure, but excluding that kind of an event, do you see it happening?
we have given state a possible new process, demonstrated there is a process that could make this go quicker. I think, and state has sort of acknowledged that they need to do something. So I guess from my perspective, I just need to see what happens now.
Okay, so we're back to hope. Okay. Excluding hope for a moment, you earlier said that you were given access sort of very broad but not very high, that you, up to a point, you were given good access, and then after that, some of the details at higher level that would have helped you understand the problem and maybe suggest more, you were denied. Is that correct?
Well, from our perspective, we got the access we needed to complete the work. So that's important to note. And the focus was on the process. So we spoke with all of the key parts of state that was dealing with the actual creating of the report. When we recognized, though, that this process and how it's run is probably out above the people who are doing it, the decisions on changing it are not up to them, we thought it would be a good idea to actually seek out some views of the higher level officials. And we did request those meetings, but we didn't get them.
So one thing that Congress could do in appropriation or other appropriate areas, insist that you have that access so that perhaps beyond hope, you could also have participation. Is that correct? You're not lobbying, we're asking.
From our perspective, we got the access we needed, because I thought it was actually instated, it would have been to their advantage to have had a meeting. If it actually would, if I needed that meeting to complete the work, then I probably would have gone through a more legalistic process, but I did not need that meeting to finish my work, but I thought it would have been helpful to state to have had that conversation.
And let me just close, and I know, Madam Chair, this has been said many, many times, but since I alluded to, you know, we're not going to get where we want to be in the next 18 months. You at GAO are great at giving corrective action and then advising Congress in your role in our branch on what to do in the future. If you could take the remaining time to the extent that you can and tell us, how could we better write and oversee requirements like this so that we could get and expect compliance? Is it that we need to pre-negotiate? It sounds like they've said 6 months was enough. They're just behind. What is it we could do different? Because I know the chair would like to do better next time so that we wouldn't be at fault for these reports.
I think the law is quite clear, so I don't know if the law needed to be clearer. So
You're just saying that you need people who will obey the law?
I think there probably needed to have been a dialogue between the Congress and state earlier. I mean, these laws, these reports have been delayed for a long time now. So it's possible that they didn't think that they needed to meet the law. I don't know. It's a question they never really answered. But I think Congress's concerns were not necessarily being received.
Well, you know, the interesting thing is state in another committee told us that the reason that Ambassador Stevens didn't get more security is he didn't ask enough. He didn't insist enough. That after asking for and saying things, including on the day he died, that it wasn't a question of if but when there would be an attack, he didn't ask enough. I appreciate it, Director, and we'll try to figure out how to ask more. I thank the gentlelady. Yield back.
Thank you, Mr. Issa. Mr. Clausen of Florida.
So, thank you for coming today. Appreciate it. The process slows almost to a halt. Takes a long time to get to final decision. Then it takes even longer to get a final decision. In the meantime, that creates space, time for the State Department to renegotiate deals they don't like anymore, slow down on deals, use the threat of this sanction that's out there that we haven't really applied yet because our process is so low or so slow. So you kind of have this, and then we blame it on bureaucracy. But if it really is bureaucracy, it kind of helps the State Department and the administration around the intent of the original process so that they can retrade the deal and do what they really want to do with these folks. And so it doesn't sound like a bureaucracy problem at all. It sounds like somebody playing on the margins of the law in order to create space to retrade a deal they don't like anymore or never did like. And then we're in a position where we have no recourse unless we want to change the law, which is hard to do because there's a Democrat in the White House that likes retrading these deals. Did I summarize that correct?
I think GAO provided you the what. You're asking me for the why, and I can't really give you the why, but your narrative is as reasonable as any others I've heard.
Yeah, but I am saying that to focus on procedural delays, when those procedural delays coincidentally help the State Department retrade the deal, I mean, we've got a mishmash of incentives here that we're not being, the American people deserve clarity. If I'm going to sit up on this committee, I'm going to speak clear about what's really going on as opposed to yakking around the edges about bureaucracy and steps in the process.
And I understand perfectly. GAO, though, can only really talk about what we can observe. And you're asking about things we could not observe.
I have nothing then I can add to that. We need to figure out on how to use the power of the purse or the power of changing the law, so that what we do, the process actually reflects reality on what the original intent was. Thank you. I yield back.
Thank you so much, Mr. Clausen. Dr. Yoho, also of Florida.
Thank you, Madam Chair. Appreciate you being here, sir. In their response to the GAO's study, states stated that further challenging the ability of the department to deliver INCSA reports within the statutory time frame, the law has subsequently expanded its scope along its evolution. The last time the law was amended was in 2006, adding North Korea. What was state's response to the fact that despite no changes in the scope of the law since 2006, the time that state requires to produce a report for Congress has increased? I mean, what was their reasoning?
State mentioned that they thought because of scope changes that was contributing to it, but we don't think the scope has changed.
Well, they've had since 2006 to get their act in order.
And that's the period of time we're looking at. And we also observed that the time between reports is getting longer, not shorter.
Right, and you've offered, the suggestion of do we need to expand it to a year, but yet they said no.
They did not think the law needed to be changed.
All right, what do you believe would be the most efficient method for eliminating the current backlog and also keeping up with the future deadlines?
I think state could implement a 6-month reporting cycle.
Is it a shortage of help?
They did not say they needed resources, but I think if state may want to actually have a conversation with Congress about that, because it was at the bureau level. I think that should really be at the deputy level to really decide that.
Who is the person at state, the individual that is responsible for that study?
It's an individual in the International Security and Nonproliferation Bureau. I'd rather not name the name because
you don't have to, but there is one person that is held accountable for this.
There is one person, although ultimately it's a deputy secretary. Because ultimately, the deputy secretary is the deciding official.
All right, so somebody can be held accountable.
Yes.
And somebody, if they're held accountable and they're not performing their job in the private sector, would be removed from that job. That could happen here, correct?
I assume so.
I would hope so. And I think that's something, Madam Chair, for another meeting would be wonderful. Let me ask you this. What is the impact of, what impact has state's delay in reporting had on sanctioned decisions?
The way the INCSNA law is written, you can't make an INCSNA sanction decision until you first report to Congress. So in December of 2014, we got the decision on 23 cases that were observed in 2011. So between the time the State Department became aware of a problematic transfer and actually sanctioning was between 36 and 48 months later.
And
Later.
with the critical negotiations we are at with Iran right now, a period of time, a delay like that is unacceptable. I mean, you're reporting on something that happened 24 to 30 months ago on today's decisions. And I just, would you feel that would weaken our hand at the negotiating table?
We observed, separate from any of the negotiations, we are concerned about the credibility of the sanctioning process.
Well, I was going to get into that here.
To my mind, the sanctioning process requires relatively timely action.
Yeah, I mean, you want it timely. It's like disciplining a child when they're wrong. You don't want to wait until they're 18. According to your report, State Department officials told GAO that they believe that the threat of imposing sanctions can be effective with what you just brought up as imposing sanctions in achieving the behavior change that sanctions are intended to motivate. However, did they quantify this claim? And if they believe that, they would be reporting quicker, wouldn't you think so?
As to the first part, I think they may have a couple of examples, but any example cannot be done publicly. So I would think that you would benefit from a briefing from them in a classified setting where they want to give you some of those examples.
I've got an example here. 17 of the 18 foreign persons that have had sanctions imposed on them have actually had the INCSNA sanctions imposed on them for more than once. That's correct, isn't it?
Yes.
In your opinion, would that undermine state's suggestion that the mere threat of a sanction is just as effective as the imposition?
That's a very fair question.
And again, you know, you can only threaten so long before you act.
Yeah.
Let's see. What is the effect of the administration's failure to implement these non-proliferation sanctions, particularly against Iran? And I think I kind of covered that and you kind of answered that, but in this
I
one...
cannot talk about individual countries.
Okay, I understand.
Yes. So.
Thank you, sir, for your time, and I yield back.
Thank you, Dr. Yoho. Mr. Weber of Texas.
Thank you. Director Melito, forgive me if some of this were done because I came late. And so I didn't hear your remarks. I'm looking at your testimony here. According to your testimony, you talk about from 2006 to May 2015, the state imposed sanctions on 82 foreign persons located in 10 nations, including China, Iran, Syria, North Korea, Sudan, and Russia. Once imposed, INCSNA sanctions are in effect for 2 years at state's discretion. Okay. So there was 82 foreign people in those 9 years that you've identified.
Yes.
So you go in and you look at the process. Is that number, that percentage of people who were identified and sanctioned, is it rising? Is it raising or lowering?
It goes up and down, but the most recent report covering 2011 had the most in any of the years, which from 2006 to 2011. The 23 was the single largest year.
So that was the largest year. So that kind of answers the doctor's question about does the statement, even the threat of sanctions seems to work. If you looked at the numbers, that'd kind of be antithetical, wouldn't it?
It seems the activity may be increasing, but I actually don't know that, and that would actually be...
Well, you don't think they just chose those people out of a hat? I mean, the activity is obviously increasing.
Part of this is actually becoming aware of of activity. So some of it may have occurred before 2011. But again, any of this kind of conversations requires information that cannot be discussed publicly.
So how far, did you go back to 2006?
Yes.
Okay. So did you identify in 2006 what the first report do, where the problem was? Who was responsible? Where did the buck stop?
We have a table in the statement for the hearing, not for the report, which gives you how long in months each of the 6 steps take, and
Okay.
our general summary is the steps that are inside state's control take the longest. And in the most recent report, the actual final approval by the Deputy Secretary took the longest.
But identify in 2006, that first person, that first step that never got the ball rolling.
Um,
I mean, you can do it by a position. You don't have to do it by a person's name. Can you do that by position?
So the report that covers 2007, because
Let me restate it this way.
Right.
Does state have a process whereby they start to put this report together? Have they built that outline?
Oh,
And
yes,
are-
and we did review the statements of.
All right, now we're getting somewhere. In that outline, what's the first office it goes to?
We have a flow chart in the report,
Okay,
which, in the actual report itself on page 9, which goes through the 12 steps.
Okay.
And it starts, so there are these expert groups.
I don't want to turn to page 9.
But I'm going to just say one thing quickly. There are expert groups which are responsible for missile proliferation, biological, chemical, nuclear. They're meeting every 2 to 4 weeks.
Okay.
They're not meeting just for
So
English.
somebody compiles the report of these export groups.
Yes.
Help me, who is that office? What position is that?
That is the International Security and Nonproliferation Bureau of State Department. They're the ones who are responsible for.
Is that same person there now that was there in 2006?
We actually do not know.
You actually do not know.
We didn't ask that question. Well,
Okay,
oh,
so
my staff just told me that they think he was.
they think he wasn't
alleged
there, but
officer.
now he is there.
They think they actually, they're telling me that the person who
He is
running
there.
the office now was the same one who was there then. Yes.
Do you know the reason why?
I do not know.
Could it be he or she wasn't held accountable?
That's a question for state.
Okay, but you're the GAO. You come in and you weigh in on these things, the process, right?
We actually did not think that that bureau itself was where the problem was. That bureau was following a process it was told to follow. We would like the question to go to the Deputy Secretary.
States delays, in your testimony, you state states delays in reporting on transfers and acquisitions have recently increased. Why?
The why is hard to answer. We can show you what parts of the process it's taking. It's taking much longer for the Deputy Secretary to approve it. Why it's taking him longer, I cannot tell you.
Okay, so let me ask you this question. I've got 22 seconds left. You don't know, well, you do know who was responsible, and first you didn't think that person was still there, and now you think that person is still there. So we have a backlog. So is it a good premise to say, to fix this problem, let's let the backlog sit for a minute, and let's start today, now, and get somebody accountable in that process that's got us a report in less than 6 months? Is that feasible?
I think it is possible for state to decide this year to start reporting every 6 months, and they would release whatever decisions have already been completed.
Okay.
Those decisions would cover multiple years.
So,
And they could do that, and I think, and still continue to fully vet the cases that take too long. They take a long time.
okay. That doesn't make me happy, but Madam Chairman, I'll yield back. Thank you.
Thank you so much. Those are excellent questions, Mr. Weber. And if I could just ask one question. Is the State Department taking longer or longer to make these reports and implement the sanctions? If that is what's happening, does this diminish or bolster the credibility of the threatened sanctions? Because if sanctions are not being effectively implemented and the delays in reporting are hindering their application, how credible is the threat to impose INCSNA sanctions? And did you raise this issue with state, and if so, how did they respond?
GAO observes in the report that a long period of time between observing a sanctional action and sanctions probably undermines the credibility of the sanctions. State disagreed with that, but to my mind, 3 to 4 years after you observe something is too long.
It's too long. Thank you very much. Director, please give your thanks to your team for excellent work. Thank you, ladies and gentlemen. And with that, our subcommittee is adjourned, but we look forward to working with you on making sure that they follow the law. Thank you.